Morning, everyone, and thank you for joining us for today's session, where we will be discussing the return of Commonhold following the announcement by Housing Minister Robert Jenrick that he is establishing a Commonhold Council. My name is Stephen Smith, and I'm delighted to be joined, as always, by Ian Quayle and my colleague Robert Kelly. Good morning to you both.
Morning, Stephen. Morning, Robert. Morning, everyone. Thanks for coming along again.
Just before I hand over to Ian, as per usual, I just want to go over a few items so you can participate in today's event. As I'm sure most of you are aware, you are listening through your computer speaker system by default, but if you would prefer to join over the telephone, you can just select the telephone option in the audio pane and the dial-in information will be displayed. This is a free, toll-free number, so if you do want to use it, it's very reliable as well. You will have the opportunity, as always, to submit text questions to both Ian and Robert, myself, by typing your questions into the questions panel of the control panel. You may send in your questions at any time during the presentation, and we will collect these and address them at a Q&A at the end of the presentation. Just finally, you can also raise your hand if you're having any IT problems. There's a raise hand function, so please do that, or please do send me a message if you're having any IT or sound issues, and we'll try and address those as well. You will also see that we have the notes for today's presentation in the handout section, so please feel free to download those. If you're having trouble doing that, again, please get in touch and we can arrange for some to be sent to you. Anyway, without further ado, I will pass on to Ian for the main part of today's presentation. Thank you.
Thank you, Stephen. Thank you, Robert. Thanks, everyone, for coming along. Yeah, today we're going to look at Commonhold, basically because, as Stephen says, we've had the heads up from government that something needs to be done, and perhaps Commonhold is the solution with regard to leasehold problems. A little bit of history, really, relating to Commonhold. Of course, created by the Commonhold Leasehold Reform Act 2002. Very, very few Commonhold schemes live when the 2002 Act went live in 2004. Approximately 20 Commonhold schemes in the UK, not all of which are active. I think last time I looked, 8 were active, and a pretty resounding disaster, really, in connection with the original launch. As far as if you go back and look at Commonhold, as I've done, because I was around when it was originally launched and looked at it and did a lot of training first time around, based on an Australian model, to be honest with you, with a few refinements. It's a model that you do see in Australia and New Zealand, and anyone that's practiced in Australia and New Zealand will be familiar with the concept, although not necessarily the terminology. The Law Commission looked at leasehold reform, was supposed to report in the spring of 2020. In fact, they submitted their report in September 2020, and again, there's lots in that report with regard to how Commonhold can be reviewed and revised to improve it and make it more palatable, both for developers, the legal profession, and unit holders, formerly leaseholders. The million-dollar question is are we really going to see it? Is the government really anxious to do away with leasehold and to force Commonhold upon us? I think if we didn't have all the other problems and we were just dealing with the leasehold problem, then the answer to that question is we would see it very quickly indeed. Given the current climate and all the other problems that the government is fighting with, then again, I think there isn't really an appetite for it to be introduced rapidly. That said, if things steady down this year, perhaps next year we'll look at its launch, or if there continue to be problems, such as the cladding issue, such as the issue with regard to leases and the sort of ground rent problems, etc., we might just see it being introduced, perhaps in connection with new schemes, and then with an aim or an intention to look at converting existing leasehold schemes at a later date. Certainly the government in 2021 has a little more control over developers than it had in 2002, 2004. Things like shared ownership leases, things like Help to Buy, and all the sort of government funding that's going in to assist developers means that I think the government has far more of a lever with regard to developers to compel a change in style, a change in approach, so that leasehold is jettisoned and perhaps Commonhold introduced. So a lot of things to talk about. The purpose of today is to give you an overview with regard to Commonhold and to show you, as a conveyancer, as a lawyer acting for a developer, some things to look out for. There were some fundamental problems with regard to the original scheme that the Law Commission has attempted to address and deal with, not entirely satisfactorily in my view. I want to show you what those problems are. So you should have access to the notes, as Stephen mentions. Hopefully you can see the screen. As far as the first point is concerned, we've touched on this. Take-up has been very poor. I wasted a year of my life learning about Commonhold, literally quite intensive learning, then spent a year going up and down the countryside delivering training on Commonhold. And again, because of the sort of the marketing from the government about this new form of freehold ownership, there was a certain degree of excitement amongst the legal profession relating to it. But then very quickly, because of poor take-up, that sort of interest and that sort of demand for training disappeared. It's certainly resurrected itself this year, which is why we're here today. Why is Commonhold back on the agenda? Problems with leases. Ground rents, the Grenfell problem, major problem there. The government is throwing money at decladding, recladding issues, but it's not enough. On a daily basis these days, we're seeing publicity, news items with regard to leaseholders who are being left high and dry with regard to service charge, demands for payment, etc., that they can't meet, and therefore a contention that residential leases aren't fit for purpose. In addition to that, residential leases are clunky and cumbersome with regard to mixed-use schemes. And one of the things I want you to take away today is the fact that Commonhold does work in a mixed-use scheme and shouldn't simply be looked at as a means of dealing with diverting, altering or changing existing residential schemes. There is an attraction with regard to freehold ownership. Now, whether that attraction is justified or not in the context of flats and apartments is an interesting argument, but certainly the SRA, other trainers, other providers have been advising the profession about the need to ensure that if we've got clients acquiring a leasehold interest, they understand that they're in a radically weaker position than they would be if they were acquiring a freehold interest. And therefore, the idea of Commonhold providing unit holders, the equivalent of a leaseholder of a flat or apartment, acquiring the freehold to their flat or apartment, has an attraction. And then finally, this point that I make on the bottom of the screen, is Commonhold a way out of the decladding, recladding financial turmoil? In that regard, when we're talking about converting a leasehold scheme into a Commonhold scheme, as you'll see that there are things that a Commonhold association could do, which in essence replaces the equivalent landlord with regard to funding, with regard to generating income, that might mean that this is an easy, efficient and relatively cheap way of resolving cladding problems. Instead of the government throwing billions at buildings to ensure that they are safe, with all the good publicity that generates and all the sort of comfort that safety produces, if we're able to come up with a scheme that means we don't have to fund directly repairs, recladding, decladding, but instead fund the conversion of existing leasehold schemes into Commonhold, then that may be a cheaper option, a better option in connection with spreading risk and spreading cost. So whilst I'm saying the government may think about just introducing Commonhold for new schemes, if I'm right in thinking this might be a way of dealing with cladding issues and fire safety issues cheaply, then we may see, in addition to new schemes, the government pushing forward Commonhold in the context of converting existing leasehold schemes. I deal with that in the notes and in my presentation this morning. What is Commonhold? At its basic, it is a situation where you have a Commonhold association that owns the common parts to a block of flats. It is the freehold owner of the flats. It owns common parts, structure, airspace, roof voids, subterranean strata, etc. and in essence replaces the freehold landlord. Nothing unusual with regard to that. Where it is unusual is that instead of having flats or apartments, or indeed commercial premises within that building, we have a system of freehold units that derive their title from the Commonhold Association and from the freehold. So it's a variation of an existing freehold scheme, with unit holders having two distinct interests: a direct interest in the freehold unit in connection with their flat or apartment, and also an interest in a Commonhold Association, thus the communal parts. So the Commonhold Association, quite simply, replaces our landlord. The Commonhold Association is owned by unit holders, and the Commonhold Association is a forum or a vehicle that has been designed to ensure that unit holders are protected, and designed to ensure that Commonhold is attractive for unit holders, rather than having a landlord that potentially is deriving profit from their reversionary interest, or being disinterested with regard to management relating to the building or property. If a Commonhold Association is owned by unit holders, then it's implicit that they have an interest, a need, and a wish to ensure that common parts, communal areas, etc., are kept to a good standard, whilst at the same time ensuring that good value is generated with regard to the provision of services and costs relating to repair. Now, there is a fundamental problem with regard to Commonhold that the Law Commission has touched on, and that a number of commentators have also identified, and that's the sort of the human element in all of this. Okay, we can have bad and good landlords, bad and good management companies. If we have a Commonhold Association that is run by unit holders, in essence leaseholders, then again we'll have exactly the same problems that we're currently encountering with regard to management companies that are owned by currently leaseholders. So I don't think that what we're doing, what is being intended, is going to resolve that potential fundamental problem. The Law Commission has put in place suggested reforms with regard to the existing Commonhold scheme to address those issues. But whether they are properly addressed is a different story, and human nature being human nature, the likelihood of arguments, disputes, etc., contentions, dissatisfaction amongst unit holders, no matter what the forum or vehicle is for property ownership, remains. There is another problem with regard to the Commonhold Association that, again, the Law Commission has identified and attempted to address. But it was something that I used to warn practitioners about back in 2004, and we've got exactly the same problem today in 2021. A Commonhold Association is a company limited by guarantee. In essence, it replaces the landlord with regard to management. So let's assume that we've got a company that is doing work for a Commonhold Association, and that work relates to lift repairs, significant lift repairs. The cost of those repairs, £60,000–70,000. No reserve fund, no appetite to borrow money to meet the cost. The intention is that the Commonhold Association is going to recover this cost from unit holders in the equivalent of a service charge. And surprise, surprise, some unit holders are saying, we ain't got the money. Some unit holders are saying, we disagree that this work should have been done. And we're left with a position where the Commonhold Association doesn't have the means to discharge that liability. Let's assume that our lift company is nasty, hungry for money, and not willing to mess around, delay, discuss, or offer any form of accommodation. They go straight for the jugular, issue proceedings, and obtain a judgment. The judgment is unsatisfied. The lift company is of the view that the Commonhold Association is being unreasonable and immediately contemplates liquidating the company. Company liquidated, company then dissolved. In the existing scheme, there was provision for the creation of a successor Commonhold Association. But again, the mechanics for the creation of that association were quite clunky. Law commissioners looked at it to see if there's something that can be done to make it a far smoother opportunity for a successor Phoenix Association to be generated. But if it didn't, if the unit holders are at war with one another and no one is willing to create a Phoenix Commonhold Association, if the original Commonhold Association, which is the freeholder of that development, no longer exists, then the entire Commonhold concept falls apart. That was a problem back in 2004. That potentially is a problem today. Now, a number of points. Firstly, as I've mentioned, the Law Commission has tried to address that and make the creation of a successor Commonhold Association easier, so that we're not left in this situation where our Commonhold disappears. But the problem with that is there is still the issue that if I am advising our lift company and I'm wanting our money and I'm wanting to exert pressure, the fact that I can make this association disappear may mean that unit holders and indeed everyone else that's interested in the Commonhold Association are going to do everything in their power to pay me. That's good news for me. It means that I'm more likely than not to get paid. But it also means that I'm more likely to push and be quite aggressive. And if I push and I am aggressive on the basis that I think not to worry, the Commonhold Association as is disappears, but a successor association comes along and will have to pay me or resolve the problem with me, I may be fooling myself on the basis that the Commonhold Association disappears, is dissolved at Companies House, and nothing takes its place. So that doomsday scenario still exists and will always exist, no matter what I'm saying, and no matter what the Law Commission or indeed anyone else try to do to ensure that that position can't possibly happen. Advantages of the Commonhold as proposed: standardized documents. We have a Commonhold community statement, which in essence is the linchpin of our Commonhold community. Originally, back in 2002 to 2004, this was a standard document that was created by government, and there were no amendments permitted. So it was one community statement that applied en bloc throughout any Commonhold scheme within the United Kingdom. Law Commission is saying we shouldn't really do that. What we should do is have a basic community statement that applies en masse, but we should have an opportunity for variations, local statements for local developments, or even blocks within developments. So the Law Commission has said this idea of standardized documentation is good, but we want some form of opportunity for flexibility. And so we've got a bit of a hybrid now being recommended by the Law Commission. There is a standardized conveyancing process. Again, that was agreed back in the day in 2002, and we're seeing exactly the same thing being ventilated today. So not much of a problem relating to it, and standardized memorandum of association and articles of association. Therefore, if we're looking at the conveyancing process with regard to a Commonhold unit, the process should be simplified, the process should be quicker, and the process should be cheaper, because we are looking at a document, the Commonhold community statement, that is the same no matter where we're buying our property. There will be some localized rules, as it were, for a particular unit or a particular development, but those rules are going to be nowhere near as substantial as what we'd be seeing if we were looking at a residential lease. The standardized memorandum of association and articles of association, again, are going to help us in that we're not going to have to look and trawl through and give advice on particular schemes and on particular companies. We will have one raft of documents that we will be familiar with, and we can use standard letters to advise our clients about their content and their obligations and duties that arise. As far as new Commonhold schemes are concerned, again, the current regime is the same as that which is intended in essence. We can have a developer that creates a Commonhold scheme. They will register a Commonhold at the land registry and will do so without unit holders. The idea of the original scheme was that a developer could create a Commonhold scheme and then could see what the appetite was like for people to buy units within it. If there wasn't an appetite, if sales staff were being told, hey, this is great, we love the flat, we love the apartment, but our conveyancer is saying, we don't like Commonhold, we don't know about Commonhold, or there are some fundamental flaws with regard to Commonhold, and therefore take-up isn't good, it is possible for the developer to go back to a leasehold scheme. That's as currently the legislation permits. Okay? So we have a Commonhold scheme without unit holders. It's registered at the land registry. We start selling units. If we're selling units and there isn't any opposition to the Commonhold, then units are sold and they're registered under different title numbers. The common parts have their own title number. Each unit is a freehold unit. The Commonhold Association creates a Commonhold community statement that is binding on unit holders. As I've mentioned, there is an opportunity for local variation and personalisation with regard to the Commonhold community statement, but the main theme, the main thrust of that statement is consistent throughout the country. Once one Commonhold unit is sold, the opportunity to convert the scheme back to leasehold is lost. Now, it seems to me that if we've got the current attitude of government, we don't like leasehold, and if we're saying Commonhold is our magic fix with regard to landlord-tenant leaseholder relationship problems, then we may see a situation that once a scheme is created and registered at the land registry, a developer can't convert at all. He's committed into a Commonhold scheme. To do that, I think there'd need to be some form of government incentive. But at the moment, we can create a scheme and then in essence withdraw before we sell a unit. So we can test the market. Now, the million-dollar question is, are people going to pay more for Commonhold units than they would for leasehold flats? Or are they going to regard a Commonhold unit with some skepticism, meaning that there isn't going to be an appetite for purchase? At least with leaseholds, they're bad news potentially, they are problematical, but we know what we're getting. Our conveyancers are comfortable with leasehold schemes despite all their problems and all their issues. Again, certainly speaking to developers, dealing with developers and acting for developers in 2002 to about 2005, most of them were saying the market doesn't want Commonhold. You know, the government was suggesting that you might even get a premium for flats and apartments on the basis you're selling the freehold to a flat and apartment. You've not got the risk of a nasty landlord, the sort of big bad wolf sitting in the corner, demanding management fees, service charge, ground rent, etc., and being entirely unreasonable. So government was saying, Commonhold, Mr. Developer, is great for you. You're going to sell units and make more money. The reality was there wasn't the appetite either from buyers or indeed their lawyers or indeed the sort of market generally. So are we going to see a change in that? I don't know. We were just talking earlier about the market and you know, a lot of people saying, well, yeah, during the current SDLT window, the market is booming, and some like me saying, well, no, you know, when the SDLT window closes, we're going to see a crash. It's going to be a bit of a disaster. More sensible people are saying, well, that's not necessarily the case. You know, before the SDLT window, the market was pretty buoyant. These days, no matter what the economy, no matter what people are doing, there is the idea that buying property is something to do in lockdown or semi-lockdown. And the fact foreign holidays, buying foreign property is a bad move, well, that then suggests that people may well put their money into bigger and better houses or alternative houses, etc. So the market may well remain buoyant. If that is the case, the key is, if we're offering freehold flats and apartments, are we going to get a better return? Are we going to get more demand than if we're selling the existing leasehold unit? Now, my guess is, with all the publicity, with everyone reading the Sunday newspapers and watching the news or TV programs every evening about cladding scandals, nasty landlords, etc., it might be that we can look at this with a fresh pair of eyes, and we might get a surprise. And this time, when the government says green for go with regard to Commonhold, we might have a different market entirely. Who knows? If we're going to adopt that strategy, let's look at what developers should be saying and what we should be saying to clients. Remember the SRA in 2017 in their thematic review? Leases are a distinct disadvantage to freehold ownership. With freehold ownership of a Commonhold unit, we don't have a diminishing lease term with all the problems associated. We have the comfort factor of a freehold unit and the understanding of what a freehold is. We don't have landlords, and we have standardized documentation. There should be a reduction in conveyancing costs. There should be a reduction in time and energy being spent with regard to management, liaising with landlords, management companies, etc., etc. So those differences might mean relaunch is more successful. Disadvantages of Commonhold I've mentioned. One, leasehold poor management, Commonhold poor management. Is there really going to be a difference? Probably not. In the old regime with regard to Commonhold, there was a lack of leaseholder statutory rights. The Law Commission has addressed some of that, as we'll see in a moment or two. The original Commonhold scheme only allowed leases that had a term of less than 7 years. So there was a fundamental problem with regard to subletting and shared ownership. Law Commission has addressed that, identified that, and said, no, we should be able to allow shared ownership leases within the context of Commonhold, and also allowing subleases and leases to be utilised for funding purposes. There should be, as far as a disadvantage of Commonhold is concerned, limitations. There are limitations on the types of title and land that can be Commonhold. I've given you details in the notes, but things like flying freehold can't be Commonhold. Anything other than an absolute title, freehold title, cannot be used for Commonhold purposes. So there are a number of limitations relating to Commonhold that have been created and that potentially are a problem. You can't have a Commonhold of less than 2 units. So there must be more than 2 units in order for a Commonhold to be created. Important to understand that as far as Commonhold as currently sitting on the statute book, there are problems with regard to unit holder disputes and disagreements. Again, Law Commission has looked at that and come up with a variety of different methods to try and ensure that disputes don't exist. If they do exist, they're dealt with quickly and efficiently, and that they don't then impact on the financial issues and financial problems that I touched on a little earlier. So we don't have a situation where the unit holders fall out, or a minority of unit holders fall out with the Commonhold Association and saying we're not paying our contributions to the Commonhold, leaving a Commonhold Association vulnerable due to its insolvency. So as I say, the government and the Law Commission have had a look at this, and what we've got is an opportunity, I think, for some of the problems with regard to the old Commonhold scheme being successfully addressed, and the problems and issues that we saw in 2002, 2003, 2004 being alleviated. The suggested reform does a number of things. One, it promotes the benefit of freehold ownership. It highlights the role of a Commonhold Association being a sort of an arbitrator in connection with unit holder disputes. Highlights the fact that this is owned by unit holders, highlighting the fact that it's going to be a not-for-profit organisation aimed at maximising the benefits of common parts, etc., the benefits of ensuring repairs are undertaken in a timely and reasonable manner, but at the same time, ownership of unit holders, therefore able to control and manage purse strings. Standardisation we've mentioned already, but with flexibility. Commonhold community statement subject to local rules, so that we can build in particular issues relevant to a property or its location. And significantly, we can have a Commonhold development with one Commonhold community statement that applies across the board, but in connection with individual blocks of flats, we can have local rules relating to those individual blocks. So that flexibility is useful. We don't have the problem of the flexibility that residential leases provide, namely that we've got to look at each lease in isolation and advise upon each lease in isolation. We've got standardized documents and a few minor provisions in local rules that we'd need to look at and advise clients about. Promotion of ADR certainly is key. Use of a number of statutory bodies that the government is intent on introducing, some of which haven't as yet been introduced, and the idea of generating legislation to protect unit holders in the same way that leaseholders are protected. So just moving on, converting leasehold schemes. Interesting point. Under the old regime, we had a requirement for unanimous consent to conversion. We don't have that now. The current scheme the Law Commission is suggesting is we have 75% of interested parties willing to consent to conversion to Commonhold. No need for landlord cooperation. In fact, quite interestingly, an amalgamation of collective enfranchisement and conversion into Commonhold. So we can collectively enfranchise our building and then convert into Commonhold, taking the landlord completely out of the picture. That's new and that's novel and that's interesting. It highlights a point, of course, how do we fund the collective enfranchisement? And again, it may be that we see some form of government scheme to facilitate that. And again, you may say, well, where's the government going to get the money from that? I see the government diverting funds for cladding into this type of scheme so that the Commonhold Association then becomes responsible for decladding, recladding issues. If we've got non-consenting leaseholders to our conversion, the Law Commission come up with ideas. Firstly, that non-consenting leaseholders are compelled to permit conversion into Commonhold. That any cost that should have been met by a non-consenting leaseholder becomes a charge on their unit, so that when they sell it, the Commonhold Association recoups the cost or their share of cost of conversion. It also promotes and protects non-consenting leaseholders with regard to decision making, with regard to a right of redress in the event of disputes arising relating to a non-consenting leaseholder having a dispute with a Commonhold Association. So a lot of these things have been thought about, and a lot of these things make conversion far more attractive than it did with regard to the original scheme. I mentioned already that Commonhold management is undertaken by the Commonhold Association via a Commonhold community statement. These are prescribed rules, but there is also provision for local rules and also provision for section rules. If there are section rules and local rules, again, 75% approval of unit holders required to change rules. The ethos behind this is that we've got a Commonhold community statement that is common to all Commonholds, with a set of prescribed rules within them, and that you as a conveyancer simply have to look at local rules and section rules and give advice to clients that will vary depending on what those rules provide for. As far as a situation where a Commonhold Association goes rogue and wants to change rules, etc., well, then there's a 75% approval rating required from unit holders. Not to say we may get Commonhold associations that do all sorts of weird and wonderful things with regard to local rules and section rules, because human nature being human nature, we may have some unit holders that are disinterested and not participating in management, and therefore don't vote to approve or indeed disapprove, and therefore you may have a situation where the approval rating that is required is met, even though you've got dissatisfied unit holders sort of sitting within the Commonhold, accept all of that, but again, there's been an attempt to try and ensure that there is some flexibility, that we can personalize and localize rules, but that we can't allow a common hold association simply to alter rules radically, local rules or section rules radically, without the consent of the majority of unit holders. Common hold and residential leases. The Law Commission don't like the idea of a 7-year limit in connection with a residential lease being granted over a common hold scheme or a common hold unit. So the idea is, if I own a common hold unit, I can't grant a lease with a term in excess of 7 years. The thinking behind that is, if we're creating common hold schemes and dispensing with and doing away with leaseholds, why then should we create a scheme that allows leases to resurrect themselves? So the idea was that we had this 7-year limit. That created problems with regard to shared ownership. So there's now a shared ownership lease exception. Again, makes sense. So we can have a common hold unit subject to a shared ownership lease. And also, because of Sharia mortgages, etc., there is provision that enables a lease-based home purchase plan to be utilised in connection with the acquisition of a common hold freehold unit. So the Law Commission has been quite sensible about highlighting this as an issue and dealing with it. Not entirely flexible, but an accommodation that should meet the needs and requirements of a lot of people who might have been resistant to the idea of a relaunch of common hold. Funding and financial issues, big issue, big problem with regard to the original scheme because of the potential of the doomsday scenario that I mentioned, a creditor taking action against a common hold association without funds, unable to meet the liability, leading to a situation where the common hold association is dissolved at Companies House. The first thing that the new scheme suggests is that a majority of unit holders approve expenditure where the threshold required by a common hold community statement is exceeded. The common hold community statement will list and contain a cap or ceiling with regard to expenditure. If a majority of unit holders approve expenditure in excess of that threshold, that's fine, but any unit holder can then challenge that decision by application to a tribunal. So just as a tribunal will determine reasonableness of service charge, a tribunal will determine the reasonableness or otherwise of expenditure that's being incurred by a common hold association in excess of that permitted by a common hold community statement. The common hold scheme must specify what each unit holder's share of cost will be. And again, as far as that is concerned, the contribution must be paid towards all the common hold's expenditure. There isn't provision within the common hold community statement that allows costs to be distributed dependent upon need or dependent upon use. Where, however, someone is being required to pay a disproportionate contribution, there is a provision that the common hold association can create different pools or heads of cost, enabling those who have access to or benefit from services to contribute to that cost and others not being required to do so. Again, unit holders having a right of challenge with regard to expenditure and having an opportunity for the use of ADR in connection with disputes. Where a common hold association is unpaid with regard to contribution, provision that enables the common hold association to recover contributions either from the existing unit owner or new unit owners in the event of a unit being sold. So this would enable outstanding costs to be recovered from a previous owner or an incoming buyer to protect the solvency of the common hold association. Common hold associations can, but aren't required, to establish reserve funds under the existing scheme. Law Commission says shouldn't have a choice, it should be compulsory. to have a reserve fund to plan for future expenditure. Again, why? To prevent this doomsday of Commonhold Association insolvency and disappearance. The idea is that there should be a facility that reserve funds can meet the circumstances of the Commonhold. So you could have general reserve funds and then specific funds for particular purposes. Again, I'm sure this is touching towards cladding, recladding, fire safety issues, etc. And a possibility for redesignation of funds depending on need. So we might have a general fund with regard to improvement, a general fund with regard to roof or lift repairs on the basis that they have a sort of particular shelf life. Well, in an emergency situation, the funds can be redesignated to meet urgent expenditure completely unrelated to the purpose for which the fund was created. Promoting flexibility. Commonholds being able to borrow from designated funds from an unrelated purpose. Commonhold associations being able to borrow money generally, to sell off common parts or lease out common parts to raise funds, to grant fixed charges over parts so that they can borrow money secured against the common parts, the availability of a floating charge over Commonhold's future income streams. All of this designed to ensure that borrowing can be utilised to meet liabilities. One, to prevent nightmare scenario of insolvency. Two, I think, to ensure that the cladding scandal or anything like it in the future can be met internally by the Commonhold Association. That seems to be the thrust sitting behind all of this. As far as dispute resolution is concerned, the original Commonhold scheme promoted the use of ADR. The current recommendation from the Law Commission establishes an internal resolution procedure. And that internal resolution procedure is quite interesting. It enables a Commonhold association to provide an opinion, an independent opinion, on a potential breach or dispute between unit holders. The Commonhold Association should also be able to assist in Commonhold dispute resolution procedures, that there should be prescribed forms for dispute resolution. There should be a specialist court or tribunal dealing with issues concerning Commonhold, a new ombudsman scheme, a new tribunal, and use of the new Housing Complaints Resolution Service, all suggested, and inbuilt minority protection throughout, so that we're not getting unit holders taking their bat and ball home, or more accurately, hanging on to the money that should be dispatched to the Commonhold Association to meet expenses. So lots of reform with regard to dispute resolution to make the unit holder ownership and unit holder dispute far easier to resolve internally. Other suggestions, this is all again for courtesy of the Law Commission, include the idea that unit holders who are affected by a decision of the Commonhold Association should be able to challenge it to a tribunal. Okay, and so this means that we don't have disaffected leaseholders in any way, shape, or form. Anything that enables a Commonhold Association to vary the terms of a Commonhold community statement, or where they are creating local rules or section rules, or approving budgets in excess of a cost threshold set in the Commonhold community statement, should automatically enable a unit holder to challenge the decision. This is classed as a gateway to minority protection, an idea generated by the Law Commission, which radically alters and improves the existing Commonhold scheme. It doesn't matter whether an applicant has turned up to vote or not. the point is that they always have this source or resource for challenging decisions. So what can we say about these dispute resolution processes? Firstly, a lot of the schemes suggested as a means of dispute resolution are not in place. So it may be wishful thinking on the Law Commission and government's behalf. Secondly, the idea is that we shouldn't be encountering disputes relating to non-payment of cost by unit holders because of their participation in the decision-making process and because of a quick, relatively cheap method in which any disputes, any complaints that they have can be dealt with, addressed, and issues resolved. So I'm not paying my contribution to cost for the next 2 or 3 months because I disagree with the decision that the Commonhold Association has made. There is a vehicle that enables me to challenge that decision quickly and efficiently. And if I challenge it and my challenge is substantiated, I'm justified. If there's a finding against me, I've got to pay the money that's due. So it doesn't allow, as can happen with regard to leaseholds at the moment, a situation I'm not paying it, okay? Just not paying it. And if you want me to pay it, you're going to have to take me to court or take me to tribunal. We're not seeing that. It's a sort of a proactive rather than a reactive system. Where we've got unit holders that are in arrears and we are concerned about getting the money as a Commonhold Association, we should be able to seek a court order where arrears have reached £1,000 or any amount that's been outstanding has been outstanding for a period in excess of a year. Courts should be entitled to order a sale of a unit to meet the costs that have been incurred, but a sale should only be ordered where it's reasonable and proportionate to do so. So the idea here is that we've got this ultimate sanction in the event of unit holders not paying Commonhold Associations. We can take the unit from them. Again, there is provision in the suggested reform from the Law Commission that lenders are notified of arrears and lenders entitled to step into the shoes of the unit holder to meet the liability to protect their interest. But despite all of this, despite all the points that I've made and the hard work of the Law Commission to address the problems associated with the original Commonhold scheme, as I mentioned in the notes, there is the nightmare of a Commonhold Association being wound up or struck off and the Commonhold itself disappearing. I spoke to the Land Registry 2004-2005 to say, well, what happens if a Commonhold Association owns a freehold? It has to own the freehold. And if the Commonhold Association no longer exists, if you look at the 2002 Act, the Commonhold freehold title disappears. Is that right? And the attitude was then, yes, it was right. Now what we've got is, courtesy of the Law Commission's recommendations, a situation that, first of all, during the insolvency, during the steps taken before striking off, the Companies House notifies all the directors of the Commonhold Association of what is being intended, to allow directors an opportunity to address the issue and remedy the problem. Where companies that are Commonhold Associations go into liquidation, liquidators being given powers to demand Commonhold contributions from unit owners to meet liabilities, to reduce the indebtedness and thus hopefully prevent dissolution. Further, the Law Commission recommends that where a company is being dissolved or liquidated, a court has a power to grant a succession order to permit a successor association to take on the role and function of an insolvent Commonhold Association. Now, again, with regard to that, there's a trap. If we can, as directors of a current Commonhold Association, If we can jettison it and jettison debt and liability, that creates a problem with regard to people doing work for us. So going back to my lift company example that I mentioned earlier on in my presentation, if I'm the managing director of that lift company and I've been asked to do some work for a Commonhold association, and it's a lot of work, it's a high value contract, and I'm worried about being paid, okay, I need to be aware that this Commonhold association can at some stage go into liquidation, either as a result of my taking action or someone else taking action, and it could be dissolved, but the Commonhold unit holders, etc., survive because you have a provision that enables a successor association to take on the role and function of the Commonhold association, but not be responsible for the debt. In those circumstances, surely I'm going to be far more reluctant and unwilling to deal with a Commonhold association unless I'm getting guarantees. Conclusions then. What can I tell you? Is Commonhold an improvement on leasehold? Yes. Is the Law Commission's recommendations with regard to how Commonhold should be reformed an improvement? Yes. Is Commonhold a magic fix to all the problems associated with leasehold? Answer, no. Okay. At the end of the day, you've got human nature, you've got human intervention with regard to the Commonhold association. And you can have all the beautiful systems and processes for dispute resolution, but you still can't predict for, deal with, and remedy the sort of stubborn unit holder or stubborn directors that are at war with one another, the factions of different unit holders wanting different things and having different goals and objectives. So it's not a magic fix for that, but nothing can be. Is Commonhold likely to happen? I think it is likely to be relaunched. The issue is when, and we might see it being introduced piecemeal for new developments, or we might see the government deciding that this is our way out of the cladding, decladding funding issue, in which case we might see conversions first and then new builds flowing on. So the sort of thing I'm thinking of is where we've got a block of flats, we've got a decladding, recladding issue, fire safety issue with huge cost implications. Instead of government saying, right, we'll fund that, we might see the government saying either we'll fund it, but you've got to convert into Commonhold, or we'll assist with regard to soft loans for a Commonhold association if you convert. We might see that. Now, I don't have the ear of a government minister. I don't have a sort of inside track as to government thinking, but it just would make sense given what Robert Jenrick has said, given what others have said, and given why we had this announcement in January. The Law Commission reported in September. The Law Commission was supposed to have reported back in April. Why all of a sudden does the government start announcing this? There is a task force with regard to Commonhold who has been established or is in the process of being established. And again, you think to yourself, well, why would they do that if this is on the back burner, or if this is just a sop to people that are concerned about leasehold problems and about cladding issues? Is this just talk? Is this just froth to try and divert obviously aggrieved parties from venting their anger at government? I'm conscious of time, Stephen. I'm also conscious that we should have an opportunity for questions. I'm quite happy to address any questions that anyone has. Stephen, have there been any questions while I've been rambling?
Rambling, not at all, Ian. There have been a couple of questions, a bit quieter today, but just as a reminder to everyone, please, if you'd like to submit any questions, you can do so via the text panel. And if we don't answer them here, you can also contact us after the presentation. I think actually, and there was one question which right at the end there, I think you may have almost answered, but
Right.
the first question is from Megan, and she says, have
Yeah.
lenders been sounded out this time around? They weren't protected last time, so wouldn't back them. I know you've spoken a lot about lenders, but have they
Yeah.
actually been
Yeah,
involved
I
in?
think they have, Megan. I think they have. I think so.
Yeah.
I
Okay.
don't think
Perfect.
you're going to get the same resistance that you got last time with lenders just saying, yeah, fine, you can buy a Commonhold unit, but no way are we lending on it. I think the idea about the sort of protection with regard to Commonhold Association insolvency and strikeout, that put the fear of God into lenders first time around. There still is a risk, but that risk has been significantly diluted.
Perfect. Thank you. Yeah. Nikki's just asked a quick one. She said, sorry if I missed it. What is the difference between local and section rules? If you
Yeah,
could
a
explain that,
local
Ian.
rule. Yeah, good question. Thank you, Nikki. A local rule would apply to a development. A section rule would apply to part of the development. So a section rule might apply to a building, or it might to apply to part of a building. So you can section off your Commonhold. So you might have, let's say our Commonhold association owns the freehold to a development which includes two 15-story tower blocks, two 5-story tower blocks, and 15 three-story three-story buildings. Okay, the three-story buildings might have some commercial use on the ground floor and might have freehold residential units on the upper floors. Okay, the way it would work is you'd have the Commonhold community statement applying to the whole lot. You might have a local scheme relating to a 15-story tower block, and then you might have service provision for, say, the first 3 floors. So you might zone that tower block. So there might be particular rules and particular costs applying to the part of a building. So the idea is you're subdividing your Commonhold freehold unit for cost purposes and for management purposes, just as you would with regard to a leasehold scheme. I hope that makes sense.
Yeah, no, well, I think similar. It's not quite the same, but it's a kind of similar line. It's does Commonhold allow for differing contributions according to use?
Yeah.
So a mixed-use scheme has shops and flats.
Yeah,
Yeah.
it does. Yeah.
That's
Again,
excellent. Thank you.
you deal with that not in the Commonhold community statement, but in your sort of subdivisional provisions.
Perfect. Thanks, Ian. I wish I think I'd spoken too soon earlier. We've had a raft of questions, so we'll try and get through as many
Yeah, go on.
as we can. Delighted to have them, but if we don't get through them, then we will contact you afterwards.
Yeah, please. Yeah.
So Robert McAnally asks, is there also an additional with traditional real estate conveyancers taking the view that there is less work to do and perhaps therefore lower fees to be earned on buying stroke selling a Commonhold interest rather than a traditional lease? He says apologies for being cynical. He adds that at the end. So.
It could be. It could be. Could be. I mean, to be honest, this isn't. I don't think this is being driven by the legal profession. I don't think it is. I think it's governments, and it may well be, right? It may well be government saying we need to simplify the conveyancing process. So it may be a bit of that. But certainly from my own knowledge, it's not driven by lawyers. The idea is that this is being driven by government, and in turn, I think government is under pressure from leaseholders and those advising leaseholders with regard to the disadvantages of leasehold generally. And also, I think it's government thinking we've got a major problem on our hands with regard to Grenfell decladding, recladding. What do we do? How can we shift responsibility and shift the huge amount of money that's going to be required to resolve this problem? And I think Commonhold, whilst not being the answer, shifts some of the cost and shifts some of the responsibility elsewhere. But yeah, I mean, certainly, if it does simplify the process, if we are dealing with standard documentation, then it follows, doesn't it, that the time and energy that we're spending trawling through a residential lease, which is the first lease of this type we've seen, and looking at a management company and its memorandum and articles of association and management regulations for the first time, it makes sense that if we're looking at a document, the bulk of which we see day in, day out, it's going to make our lives easier. The point I want to emphasize, however, is that there may be an element of personalization with regard to documentation that would still require, us to have a look at it carefully and to see how it fits and how it operates. Sorry, Steve. Hi, Stephen. I'm just checking if you can hear.
Hello, Ian. It's Robert. I don't know. We seem to have lost Stephen. Can you hear me?
All right. Yes. Okay, fine. Can you see any other questions, or see if I can have a look?
There was just one which came up, which saying that Scotland looked at or changed the law in 2012 and effectively got rid of leasehold in return for a version of Commonhold.
Yeah.
Does that have any clues as to how things may go?
It's interesting. Yeah. When I was first doing Commonhold work back in the day, I did some work for a large conveyancing firm in Scotland, and basically what they said is, well, we're looking at a similar system. Again, as far as take-up is concerned, it's quite interesting. Not a particularly high take-up in Scotland, very similar scheme, not so much use of ADR, and of course, not the same issues and problems relating to land registration. So it's a version, okay? There isn't a sort of magic fix to say, hey, it's working in Scotland and everything's great. I can't say that. It's being adopted by some developers. I wouldn't say it's got national acclaim, and I wouldn't say that take-up has been impressive.
Right, no, it's good. It's interesting to know.
Yeah.
Well, Ian,
apologies both. I cut off there. Sorry, everyone.
Thank you, Stephen. No problem.
Yeah.
I thought I'd upset you.
Excellent. I'm not entirely sure where we got with the questions. There are still a few outstanding.
Yeah.
So I think if we do one more question for now, Ian, and then we'll go back to the rest. So someone asked, is there a possibility of existing leaseholds being converted despite having cladding issues or any issues at all?
Yeah, definitely.
Yeah. Well, yeah, that was quick. So maybe we'll try and fit in one more.
Go on.
Dispute resolution by tribunal. Are the Law Commission proposing a new tribunal or use of one of the existing ones?
Yeah, new tribunal. Yeah.
Excellent. Again, I apologise, Ian. I had a question myself. I don't know if it was covered while I cut out there, but obviously, I would say there's been quite a few in our world, if you like, property conveyancing. Yeah. There's been quite a few sort of high-profile Law Commission proposals in recent years.
Yes.
Why do you think this one is almost that they're looking at it so quickly after the proposals and recommendations were made? Some of outstanding years, aren't they? So
yeah, I was surprised, to be honest with you, because I spoke to the Law Commission in April 2020 and said, look, you said it was going to be published when there's problems, COVID, etc., etc. So it was issued in September, and I thought, like a lot of things, because Stephen, you're alluding to the Law Commission's recommendations to easements and covenants, right? Which is donkey's
that's certainly one that I can think of. Yeah,
4 or 5 years ago. Loads of work, very interesting stuff. Hey, fantastic, great. And there it is out in the long grass. I thought the same thing would happen with Commonhold because of COVID, because of Brexit. I thought, well, yeah, that's going to go behind in the queue, behind easements and covenants. So I was astounded when we saw the announcement in January, and it got me sort of waking up straight away to say, hey, he's not going to make that as an announcement and put his head over the parapet about this and then do nothing. So I think that announcement puts this way ahead of reform of easements and covenants, and indeed other reforms that the Law Commission has suggested in the property sector.
Yeah, I would certainly, I agree with that. It certainly feels that way. Excellent. Look, I think it's 12:10, so I think we'll wrap up there. So
Brilliant.
Ian, just to say thank you for your presentation today. Thank you to everyone else for attending, and Robert for his interjection as well.
Yes, thank you. Yes.
If you have any other questions, please contact myself, Ian, or Robert. As per usual, once you leave today's webinar, you will receive an automated message from GoToWebinar. If you respond to this, the replies come directly to me, so I can either try and answer any queries you have or pass them on to Ian or Robert for their input. You'll also receive a separate email from Robert, which will contain the slides and notes to today's session. And I think we're sending that in the next 24 to 48 hours. So I'd just say on behalf of Ian and myself and Stewart Title, thank you for joining us today, and have a great rest of your day. Goodbye, everyone.
Thank you. Bye-bye.